So welcome everyone in person and online. There's a audience watching via that camera just there. So it's fantastic to see all of you for our second real life events post-pandemic. And we're very grateful to Latham and Watkins for hosting us today. About 10 years ago, I was at an event in Mumbai and I gave a presentation about London arbitration, and I went on about the LCIA and its London roots. And afterwards, Adrian Winstanley, who was the Director General at the time, came up to me and said, well, you know, we're not a London organisation, we're an international organisation. But I feel as if now that I am the chair of the London branch, I can in fact celebrate the fact that the LCIA is a London organisation, and we're very proud of it as a London organisation. And we're very proud of the link between the CIArb London branch and the London Court of International Arbitration. And we've been doing these events now for, I think this is the 17th one, quite a number of years. And we very much appreciate each year being able to do it. And we very much look forward to continuing this relationship into the future. Now, one of Adrian's successors, unfortunately, couldn't join us. Jamie's on the screen there. For reasons he'll explain. But I'm going to hand it over to Rob, who's a committee member of the LCI, the CIArb London branch, to introduce all the speakers, as well as Jamie on the screen. Thank you very much.
Thanks very much, Ben. And thank you very much to everyone for coming. And I think also to the hundreds of people who are joining us remotely on Zoom. It's great to be able to do this as a hybrid event. I should just remind everyone this event is also being recorded, so best behaviour. So in keeping with the hybrid theme, as Ben said, we also have a hybrid panel as well as a very distinguished panel. And I'll make my introductions from the left and onto the screen, starting with David Joseph QC next to me. David is a barrister at Essex Court Chambers. He was appointed QC back in 2003. He's a very experienced advocate and recognised as a particular authority in the fields of international arbitration and jurisdiction disputes. And he's the author of a well-known textbook on that subject. David is also the chair of ComBar, the Commercial Bar Association, and appropriately for tonight, he's a member of the LCIA Court. Next to David, we have Sherina Petit. Sherina is a partner at Norton Rose Fulbright and leads its practice across Asia, Europe, and the Middle East. Sherina is on the board of the LCIA, the ICC Indian Arbitration Group, the SIAC Users Council, and the European Federation of Investment Law and Arbitration, having recently retired as its chairperson. Next to Sherina, we have Philip Clifford QC. Philip's a partner at Latham and Watkins in London, also I suppose my boss. He's the former co-chair of its global international arbitration practice and formerly also chair of the litigation department here in London. And in 2018, Philip became one of the, I think, still small band of solicitors to become Queen's Counsel. And very importantly for tonight, he's also the co-author of a leading commentary on the LCIA Arbitration Rules. Oh, there we go. Which, the second edition of which, I think I'm right in saying, will be appearing later this year.
Very shortly.
Not to put too much pressure on it. Then moving to the screen, joining us from, I think, the LCIA building in Fleet Street, yes. We have Jamie Harrison. Jamie is the Deputy Director General of the LCIA. He joined the LCIA after 8 years in Singapore with Adelshaw Goddard, and he's also worked at Freshfields in London and Hong Kong, Morgan Lewis, and afterwards at Winston and Strawn. So that's our panel, and obviously wonderful to have such distinguished speakers with us. The way tonight is going to work, we're going to firstly hear from Jamie from the LCIA's perspective of their recent changes to the rules. And he's going to give some insights as to how the rules have bedded in 1 year down the line. Then we will hear the views of our panel on different categories. We've grouped them firstly into procedural powers. We'll have a second segment on consolidation and composite requests for arbitration. And thirdly, we'll take what I think are two quite good subjects. We've got tribunal secretaries, always controversial, and the emergency arbitrator provisions. And after that, we will open the Q&A, which will be a little different to a usual Q&A in the sense you'll see two microphones strategically placed either side of the room. For those of you who want to ask a question in the audience, please raise your hand once you've been fortunate enough to be selected. If you could make your way to one of the microphones, a little odd, but otherwise we would have had to pass around a communal microphone, and that probably wouldn't have been the best thing to do. Those of you online, you can use the Q&A function. I will pick those up and fire them at the panelists. And we'll try and alternate between those of you here and those of you online. And I think that is more than enough from me. And I will hand over to Jamie. Jamie.
Thank you very much, Rob. I'm assuming that everyone can hear me. Okay, thank you. And thank you, Ben, for your opening remarks. We are indeed an international gathering. Ben and I first met in Singapore, and for welcoming everyone to this, which is the 17th annual event held by the Chartered Institute alongside the LCIA. And particular thanks to Latham and Watkins and to Rob for his kind introduction, but also for coordinating very tricky arrangements. They were tricky enough before I came down with some sort of mysterious sniffling after lunch and thought it was prudent not to share those possible germs with you all, but to do this remotely. It does leave me feeling a bit like the winner of an Oscar who's failed to turn up in person to collect it, but I hope that it won't detract from your enjoyment of the evening. I did also wonder if those of you with a particular fondness for the IDRC would like a last glimpse of 70 Fleet Street before it is demolished, beginning in 2 weeks' time. So please do enjoy the view. It's pretty spectacular. We're delighted to get back to connecting like this with our users and with the arbitration community generally, albeit in a strange format. It is great to see you, and I particularly enjoyed watching you with the camera off. Mingling, not particularly socially distanced, I have to say, prior to the beginning of the seminar. The title of the seminar is an update on the LCIA rules 2020, a year on from when they came into effect on the 1st of October 2020. It reminds me that back in 2019, when I joined the LCIA and the finishing touches were being put to the rules by the drafting committee, the changes were very much being referred to as an update, a light touch, and indeed were going to be launched as such, as an update as opposed to new rules. No arbitral institution likes to make significant changes to its rules too often. I think we're very aware that users and arbitrators prefer the predictability and consistency that comes with rules that have been tried and tested over many years in a variety of situations. And so the initial intention was really to update the rules to reflect primarily the changing regulatory landscape in which we all operate. And so new provisions were included in relation to these, and in particular, data protection and data privacy in Article 30A, which makes it very clear that these are all issues to be resolved at an early stage between the parties and the arbitrator, not something that the LCIA gets too involved with, I'm afraid. The second is compliance, and in Article 24A, we set out the circumstances in which the LCIA can refuse to take your case, notwithstanding you've paid a registration fee and notwithstanding the contents of your arbitration agreement or your client's arbitration agreement. There are circumstances now formally set out in Article 24A that in which we can decline to take the case. Article 31 sets out governing law and jurisdiction, clarifies that the rules should be interpreted by reference to English law and the courts of England and Wales, That is a restatement of what we believe to have been obvious, but was a great relief to our insurers, I have to say, and does add that element of certainty. The other thing to mention is Article 30.1, which clarifies that the parties must seek the same undertaking of confidentiality from all those that it involves in the arbitration, including authorised representatives, witnesses of fact or experts, and any service provider. And Article 30.2 extends that to the tribunal and any tribunal secretary or any expert to the tribunal. So those were the kind of more formal updates that had always been prepared. And the majority of what we'll cover tonight, the new rules to extend and clarify the tribunal's powers, particularly with respect to early determination and the use of technology, and composite requests and consolidation and emergency procedures, we're always going to feature in this update, and we're always part of the drafting. But it is fair to say that the benefit, with the benefit of the hiatus between February 2020, when we'd intended to launch the rules, and October, when they actually appeared, we were able to reflect the changing nature of the practice of arbitration from our own perspective and from the perspective of our users and arbitrators to tweak the rules still further. And we'll talk a bit later, and particularly about the use of technology, but I think you can imagine that that is really the greatest change, and much of those, many of those changes came between February and October last year. So it would make sense, I think, to turn to the first topic. As Rob mentioned, we're going to look at procedural powers as they're now dealt with in the LCIA rules, and in particular introduce you to two of the more important, the bigger headline changes to the rules in relation to early determination and the use of technology. Article 14, Article 14.1 and 14.2 are new rules which seek to emphasize the tribunal's general duties. We would say that these are duties that the tribunal has always had in an LCIA arbitration, but it was felt appropriate at this stage to spell them out more clearly. You will be very familiar with these general duties, and Article 14.1 outlines them clearly. On the one hand, to act fairly and impartially, to allow each party a reasonable opportunity to present its case and to deal with its opponent's case, and on the other hand, to adopt appropriate procedures to avoid unnecessary delay and expense, and to provide fair and expeditious resolution of disputes. Article 14.2 restates the breadth of these duties and the steps they can take to discharge those general duties. So it's important, having stated those general duties, to give some guidance. And what we've tried to do in Article 14.6 is to offer a non-exhaustive list of the kind of procedural directions that we would invite arbitrators to make in LCIA proceedings. Article 14.6 is there for you to read, but I will just give you the main headlines. These are all with a view to expediting the procedure to be adopted in the arbitration. So the arbitral tribunal has the power, 1, to limit the length or content of or dispense with any written statement, 2, to limit the written and oral testimony of any witness, 3, to employ technology to enhance the efficiency and expeditious conduct of the arbitration, 4, to decide the stage of the arbitration at which any issues shall be determined and in what order, 5, to dispense with a hearing, 6, to exercise its powers of early determination, 7, to set an appropriate period of time for any stage of or step to be taken in the arbitration, 8, to abridge any period of time in accordance with Article 22.1, and 9, to make any further order that the arbitral tribunal considers appropriate. So what we have in Article 14.6 is a list of the things that we might expect the tribunal to do in the course of the arbitration. The two headlines that we've focused on there are the power to order early determination, which is now in Article 22.18. 22.18 is very carefully drafted. It has wording that will be familiar to those of you who are working with other institutional rules, and focuses very much on manifest claims, issues that are obviously a problem. So 22.18 provides that the arbitral tribunal may decide to determine that any claim, defence, counterclaim, cross-claim, defence to counterclaim or defence to cross-claim is manifestly outside the jurisdiction of the arbitral tribunal or is inadmissible or manifestly without merit, and where appropriate to issue an order or award to that effect, an early determination. So no doubt we will have a lengthy discussion about what those words mean. Manifestly outside the tribunal's jurisdiction, inadmissible or manifestly without merit. Those are very high bars. The other thing just to mention briefly is technology. As I said, that now permeates the rules. And the particular highlights are Article 4, which makes clear that the default means of communication with the LCIA and as between the parties and the tribunal is now email or other electronic means of communication, and that virtual hearings are permitted. Article 19.2 is very clear that hearings in video conference or other electronic format, whether all parties are in the same place, is now possible under the LCI rules, not required, but possible. And Article 9.9 and Article 26.2 deals with the process of delivery of awards to you. On the one hand, by the registrar, who can now deliver awards to you electronically. That has really become the default means of communication now between the Secretariat and users in respect to the award. You can still have a hard copy with a seal on it if you want it, but the default is electronic. But also the arbitrators can collate their copies of the award individually, and they can be sent in separately electronically and gathered together in one document. That saves the spectre of many copies flying around the globe. Has had tended to be the case before the pandemic hit us. You may be interested just to hear a few statistics in relation to those matters. We've had 10 applications for early determination so far since the rules were introduced. 10 applications, 6 are so far undecided, 3 have been granted and 1 rejected. And I think that possibly tells quite an interesting story as to whether the power of early determination is quite as interesting to parties as we might have imagined. That was a quick scamper through those provisions, and I'll leave it to Rob to take control.
Thanks very much for that, Jamie. So let's go back to Article 14.6, which is the provision that now expressly sets out, I think, as Jamie says, a lot of procedural powers that most people would say arbitrators had anyway. So the power to limit witness or expert testimony, the power to limit the voluminous submissions that we see in arbitration these days. And coming to Philip first, obviously the LCIA has felt that these provisions need to be set out expressly. Would you say that means that arbitrators simply haven't been using all the powers that they have? And do you think that now the powers are set out expressly, they will use these powers more?
Thanks, Rob. I think this a lot of the stuff about 14.6 has obviously already been touched upon by Jamie, but I think it's important to think about this in the context of all the other sets of rules introducing a set of expedited rules for the arbitration, and the LCIA deciding, I think quite rightly, they don't need to do that in their particular set of rules because they already provide a very streamlined set of rules. There's no need to have separate rules jettisoning things like terms of reference because there are no terms of reference. So you're starting off with a very a good, simple procedure with everything that you need in it and the tools and the rules to tailor that to the particular situation. So the difficulty, though, is making sure that not only do people appreciate that that is the case, but also that arbitrators use the tools that are available. And I think also in the context of the changes we've all seen in recent months with COVID, the fact that now technology has come to the fore. It was perhaps there before, but not used in the way it has been. So now it's a really good time to have this sort of guidance and for people to focus on it. And it is a helpful checklist of things that will make arbitrators think about what could make things more efficient. And I think this should all be about efficiency. I do worry sometimes when people talk about expediting, that there's this concept that arbitration has to be quick for the sake of it. I think arbitration has to be what it has to be for the users for their particular dispute. So I think the tools are already there, but having it set out is helpful. I mean, some of the matters in that list are fairly obvious. You should set appropriate timelines for steps in the arbitration. Well, there we go. Hopefully most people would have thought of that. But there are also other matters in there, and we've just been talking about the early determination. And I think that it's definitely a good idea to have matters like that set out expressly, because of course the big concern of arbitrators with things like reducing time limits, early determination, will be the possibility of challenge, the possibility of it not being due process, and having it set out in the rules gives them that, reinforces that power that they already had. I mean, I think that a lot of people have been talking about the fact that there are so few successful challenges that arbitrators should be more robust, and I think they should be more robust, but they should also do what's appropriate in the particular case. And I think spelling out these things is good from that point of view. I think references to technology, again, hopefully it hasn't passed everyone by that there's been lots of virtual hearings recently. But I do think that if you start thinking about it in a bit more detail, you realise that actually that can change the way you even structure the arbitration. I mean, now it's much easier to have a series, for example, of short hearings if you want to. I mean, why not knock off some issues in pieces? You don't need to do everything in one go in the way that you perhaps have to if everyone's got to fly in from all over the world and you're thinking about that sort of aspect. So I think that it's a good thing. I think that it's something that will add to the confidence of people using it, but I think it's only to be used as guidance and a checklist to be considered. I think it's important that that people don't try to use these tools when they're not necessary. We shouldn't be obsessed with it, but we should also use them as appropriate, and so ultimately a good thing.
Sherina, any views on that?
Yeah, I mean, I completely agree with what Philip was saying. I mean, we all knew sitting as arbitrators that these powers were there. However, the fact is sometimes there is this due process paranoia that's there, and so you're constantly, as an arbitrator, paranoid about your award being challenged. And therefore, there is that line, or that dividing line, or that thin line between being efficient, over-efficient, and is that going to lead to my award being challenged? I think that is what then leads to cost and time delays. And I mean, I read a quote from the Queen Mary survey, which I thought was really interesting about that. And it said, and this was in the 2015 Queen Mary survey, where interviewees felt that in practice, the risk of successful challenges to arbitral awards was insufficient to justify tribunals' overly cautious behavior. Consequently, tribunals should be willing to decisively manage proceedings. And I think that's where the LCI has done a great job by putting a non-exhaustive list in there. It's a checklist to just remind you, yes, there's due process concerns, but you are an arbitrator and you have to look at each case as it comes.
I think that's absolutely right. And David, if I can come to you and to take things slightly out of order, but I think it follows. I suppose one area where one gets slightly concerned is in the area of early or summary determination, which I think you might say is somewhere at the sort of limits of a tribunal's procedural discretion. I mean, do you think the courts in England, when they're supervising arbitrations, are they going to be supportive? I thought so of tribunals' powers in this regard, or are we going to see more challenges for procedural irregularity?
Look, it's an interesting question. My short answer is I don't see why. A little bit more reasoning on that is that under Article 14.1, every tribunal has a duty to act fairly and impartially as between the parties, giving each party a reasonable opportunity of putting its case and dealing with that of its opponent, and to adopt procedures suitable to the circumstances of the arbitration. Now, if you're familiar with that language, it's because it's Section 33 of the Act, and that's non-derogable. I mean, you've got to do this in every single case. So if you do something which contravenes Section 33, it's not the rules, the LCI rules that have led you astray, and it's not the change of the rules, and it's not the introduction of early determination. It's just you're not doing your job under Section 33. So if you do your job under Section 33, you should be able to accommodate early determination. But I wanted to go one step further than that, which is this, that I don't even know that early determination is going to be a very radical measure or change to what's going on here. And the reason I say that is the three items which are identified for suitable for early determination. One is questions of jurisdiction, the other is questions of admissibility, and the other is merits. Okay. Now, as for jurisdiction, well, tribunals have since forever had the ability to make a separate order or award on jurisdiction. And because of the way jurisdiction is defined under our Act, that will actually include certain questions of admissibility. So, for example, has the tribunal been properly constituted is really a question of admissibility. So, for example, if a multi-tier clause and you're not doing the right things in order to constitute your tribunal, that's really more admissibility than jurisdiction. And tribunals have always had these powers. So I expect what is new is an early determination on the merits. But now this is the good news and the bad news. That's it's interesting that it's there, but I'm just going to be a little bit controversial. I don't know how often it's going to be invoked, because tribunals are going to be a bit cautious. They meet the parties for the first time at a procedural conference. They set out a timetable for a year's work together. And are they really going to say, well, your claim is so hopeless, Mr. or Mrs. X, I think we'll have a good long look at it next week to see if you really can proceed on this. That would be quite a punchy move from a tribunal. It would seem as though the tribunal has already had a chat and thought this it's a bit rubbishy, frankly, and I'm not sure tribunals will necessarily be that keen on doing it. So I was not that surprised to hear what Jamie said, that it hasn't been invoked that many times. I'd like a breakdown when Jamie has an opportunity to say, of the 10, how many are merits as opposed to questions of jurisdiction? I'd be quite interested to know the answer.
Thanks, David. And actually, I think you make a good point. You know, there's one that Jamie made as well. I was thinking when he referred to sort of the word manifest, I think it's a similar provision exists in the ICSID rules, and I don't think there have been many cases from recollection that they have to be truly hopeless. But just again, taking this slightly out of order and sticking with early determination, and this one's for you again, Philip. I take it from what you said earlier, you probably don't think that a very detailed procedure would be needed for early determination. I'm thinking here of the CIAC rules are a bit more prescriptive about what you should do. But are you of the view that we should be we should sort of retain flexibility, not be too prescriptive in that regard?
Yes, well, the two things, I suppose. First of all, I don't think CIAC is particularly prescriptive. I mean, they just say that you should make a detailed submission, and a decision should be made in 60 days or not if it's not appropriate. So I don't think that's particularly prescriptive. But I do think that CIAC is one of the best institutions at marketing itself that there is. And I think they've done a great job in terms of promoting some of the features of arbitration, including this sort of early determination concept. And so, you know, it's been associated with them. And I think, you know, this is something that all the institutions have to keep in mind when they're looking at what they put in and in their rules. And I think that this is something that doesn't really doesn't really add a great deal in essence in terms of what was there. It's again, it was something that was already possible. I think that maybe when David was talking about early determination, one of the things I'd say is that I don't see it as an all or nothing for the whole claim. I think this is probably going to be used more as particular arguments, particular situations, particular claims defences. But the threshold is so high for it that really it is aimed at hopeless situations, and I think that it could be useful if people focus more on picking off some of those hopeless situations. It might, I think sometimes things are allowed to go through along with everything else that could probably be picked off. I think that's the utility of it. But I definitely see the marketing potential for it for people that think it has wider application than that. I just don't personally buy it, and I think the figures are not, contrary to what Jamie said, are not at all surprising. That's exactly what I would have thought was likely to happen, because I just don't think it's in most situations, certainly in the cases that I deal with anyway, that they're very complicated. Splitting things off is like preliminary issues. Preliminary issues are a great idea in principle, and they can be very useful in the right cases, but they can also go horribly wrong and cause more delay and cost and everything else than they save. And I think that that's the decision that has to be taken on early determination. Is it really going to be helpful? Is it going to, if it's so hopeless, is anyone going to really pay much attention to it anyway? Often these hopeless aspects to cases are just sort of there, but nobody really pays much attention, and the tribunal takes its own indication from that as to how serious the case is. But coming back to your question to me, I think, in that scenario, why restrict your freedom to tailor the process for exactly what it is you're dealing with? I think it's much better to flag the point that you can do it. That way, nobody can forget about it. Nobody can think that they don't have the power to do it. Although it's not putting in some sort of special test. It's not like a summary judgment process where you have a lower threshold or anything. This is basically just saying you can decide something. If you can decide it quickly without too much effort, why don't you go ahead and do it? So I think better to leave it to the particular situation, then it can be tailored. And I think having it there means that the LCIA can say that it has this process as well, which is good. And I think that this is the right way to go. So I think the LCIA is taking the right approach.
Yeah. Sherina, coming to you, and I think relatedly, Philip's view is clearly that we should be looking at bespoke procedures everywhere. I'm thinking here more, I think, about expedition, which is perhaps, should be less controversial, but very important. Do you think we're going to see more sort of bespoke expedited procedures, and our tribunals, are they going to be robust when there's always one party that doesn't want it, inevitably? Where do you think we're going to end up?
And I think that again comes back to what I said earlier. It's the due process paranoia. And I think, let's face it, all arbitrators want to be popular because you want to be appointed again, right? So I think it's going to be unlikely, frankly, that an arbitrator who makes an award for early determination without following clear, transparent procedures is going to be Mr. Popular. And probably will not be getting repeat appointments. I wonder if a way around it is that it might be that tribunals will be aligning the procedure for granting early determination with the civil procedure rules of the seats of where they are. So, for example, in the UK, looking at the threshold for a summary judgment. So whether there is a realistic prospect of success or any compelling reason why the case or issue should be disposed of at trial. And I wonder if that is where perhaps there could be more clarity from the LCIA of what is it expecting from tribunals with, and maybe some clarification there. But I think that might be a way for tribunals to go about it.
Absolutely, and I think it's probably fair to bring in Jamie there if you want to react to that. And Jamie, also, if you want to come in with any statistics in response to David's point.
Yeah, well, I'd love to be able to do that. I've got some I've got some comment as opposed to numbers for you, other than the overarching numbers. I think from our perspective, I think Philip's comments are well made. I think it is an intentionally high threshold we strayed into talking about summary determination as opposed to early determination, and actually the two are, I think, very different. And the intention here was simply to set a high threshold for, I think somebody described them as rubbishy claims, but the manifestly poor claims, and to get rid of them early. I also wouldn't underestimate the marketing potential for the LCIA, but also for London. I think it's been quite useful for us to be able to point to Article 22(1)(8), where it's there in black and white that this power is available. I think it's something that we've always known is available, but actually it is quite helpful for us to be able to demonstrate that that arbitration can deliver that sort of result. I had a note very helpfully from the registrar this afternoon when I got the up-to-date numbers, and I've got some sort of background for the arguments that are made in the applications that we've had. Let me remind you of the numbers. We've had 10 applications, 6 are undecided, so 3 have been granted and 1 rejected. If I give you 3 examples, you have to work out which are the ones that have been allowed and which have been rejected. But there are three sort of classes of arguments that parties have raised. The first is that they claim that the claim is uncontestable because the parties have entered into a settlement agreement and the debt has been acknowledged, or a respondent states it's not a party to the disputed contract, and therefore the arbitration agreement, and it states that it's never consented to being a party. So that's a jurisdiction argument. And the third category is where there are claims that the defence is manifestly without merit and an early determination is requested. So pretty much across the board. But we've had very few, so it's very hard to give you any better detail than that. But certainly we are keen that this is a power that is used. It is interesting that we could have gone further. There's a lot of talk about an expedited procedure. I won't go into too much detail, but there was talk about a fast track procedure, and for the reasons that Philip set out, that was really rejected, not least because the process under an LCIA arbitration is pretty good and pretty efficient. You've got the Deputy Registrar in the audience tonight, so be very afraid. But she will confirm, particularly if you look at the cost and duration analysis, which is on the website, that the average LCIA case takes between 11 to 12 months from the request through to the final hearing. And that's pretty good by reference to any arbitral institution, and not bad in relation to, in comparison to court litigation. So it was felt really that, as Philip said, that the existing tried and tested LCIA rules would do very well for all classes of case, rather than an expedited procedure for some.
Shall we move on to composite requests for arbitration and consolidation? And Jamie, you get to go again and tell us about this.
Thank you very much. Well, the composite request is a very significant update to the LCIA rules. It appears in Article 1.2 and 2.2. It is the LCIA's response to the case of AVB, which I'm sure you're all very familiar with. Essentially, the court held in that case that the LCIA rules 2014 didn't permit a claimant to commence proceedings under multiple contracts in a single request, but instead the parties needed to issue separate requests. So what you have is an opportunity to file a composite request. So you can commence more than one arbitration using a single document. So if you want to commence more than one arbitration under the same arbitration agreement, or more than one arbitration under different arbitration agreements, you can now do so with a composite request in a single document. I ought to be honest and say that there are a few stings in the tail. One is that we open a separate file in relation to each claim which appears within a composite request. You get a separate file, you get a separate claim number, and I'm afraid that costs you a separate registration fee. The other thing to mention is that filing a composite request does not automatically serve to consolidate the claims that you make, and that is still a matter for you to put to the tribunal, or in fact now to the court, as you're doing at the moment. So composite requests are made under Article 1.2, and there's a corresponding right in Article 2.2 for the filing of a composite response. Hot off the press, I can tell you that we have registered 21 composite requests, within which we've started 78 cases. So I can't tell you what the run rate is since the rule came into effect in October, but I can tell you that a large proportion now of new requests within the LCIA are started by composite requests. Wing, I think, would be able to tell you, because these things tend to happen on a Friday afternoon. But the worst one of all, I think, was 15 or 16 cases within a single composite request, all of which have to be registered separately and dealt with independently. So they are quite a big ask on the Secretariat. So 21 have been by composite request, of which there were 78 cases. So I say that composite requests and composite responses don't lead automatically to consolidation, but what we've tried to do is to extend the range of circumstances within which you can apply for consolidation under the LCIA rules, mindful that this is a central plank of what we've been trying to do with the new rules, to enable people with multi-party contracts, multi-party disputes, to bring all of their claims at the same time or together. Under the 2020 rules, we've moved what used to be Article 22(1)(9) and 10 to a new Article 22A. That also deals with concurrent proceedings, and so consolidation and concurrent proceedings are dealt with in Article 22.7 and 22.8. Just to run down what 22.7 gives you, Article 22.7(1) provides that consolidation is possible with one or more other arbitrations into a single arbitration subject to the LCIA rules, where all the parties to the arbitrations to be consolidated so agree in writing. A party can apply under Article 22.7(2) to the Tribunal, and with the agreement of the LCIA Court, can consolidate cases not just under the same or compatible arbitration agreements, but now where the dispute arises out of the same transaction or series of transactions, even if the parties are not the same, which offers the possibility of consolidation in a much wider set of circumstances than was previously available. So where the dispute arises out of the same transaction or series of transactions, even if the parties are not the same. The update also expands the power of the LCIA Court under Article 22.8(2) with respect to consolidation. So the LCIA Court can now order it prior to the formation of the Tribunal in similar circumstances to those I've just mentioned. And also the LCIA Court can now order consolidation where the parties agree in writing. So the powers of the court are aligned with those of tribunals, and there are options to consolidate right at the very outset of proceedings. The data on these provisions is slightly more interesting than the data has been so far, in that we have had 15 applications to the LCIA Court for consolidation of claims prior to the formation of the tribunal. So 15 applications, 14 of which have been allowed. In 8 of those, there was no agreement between the parties as to consolidation. So there have been 15 applications and 14 have been allowed by the court. So back to you, Philip. Back to you, Rob.
Let's go to Sherina first, I think. I mean, in practice, Sherina, we've heard a lot about composite requests. And I assume it wasn't you that filed this mammoth composite request. Maybe you can't tell us, probably that. But in practice, how important is it to be able to do that?
I mean, I think it's useful to have in the rules because of A versus B, and you know, so and obviously it's I think people will perceive it as time and cost saving. But I mean, I don't know if that's the elephant in the room, but administratively, you know, is it just the same thing packaged up, frankly? Because as JB said, you know, you will be getting separate, you know, you will be having to proceed, all the arbitrations will proceed separately. The LCI will be opening different files. It'll be sending separate communications to the parties. Very importantly for a claimant, you know, the registration fee is considered separate. And all of the different requests will have to comply with Article 1.1 as well. So, you know, I guess some people just wonder, is this just a nice, neat package? But is it really the same thing where instead of putting 15 sheets of, you know, 15 different requests, you're actually bundling it up into a nice little package and sending it off? But actually, it's the same thing. So I don't know.
Philip, you were telling me that you filed one not too long ago. Any comments?
I have. Well, so yes, I mean, I've been involved in them from a couple of different angles, but the thing I would say is that some situations you clearly have claims which need to be resolved together, and in those circumstances, you know, filing all the different requests is unnecessary. If you have claims that are, and you heard from the statistics there, you know, nearly all of the requests for consolidation were granted. So, I mean, that's not really that surprising, I don't think, because you would imagine that people would only do composite requests where that's what they were going to do. And in a lot of those situations, it's going to be absolutely obvious that they should be consolidated. And then putting it all in one place makes it a lot better. I mean, yes, you have to pay the multiple fees, which is unfortunate, but the fee isn't that high. So, you know, in the great scheme of things, that's not such a big problem. You sort of probably have to do it that way, because if you don't, what happens if you, in the situation where it doesn't get consolidated, it would then be a bit weird. But in circumstances where it does, at least then you've just got the one request and you go back into the single procedure. So although you've had to pay and it's had to be dealt with separately, in fact, in a lot of these cases, I think you'll find that so much of the fact base is the same that actually what you end up with is a request that looks like an ordinary request with a section in it that then has to be broken down into the 8, 10, whatever bits that have to be done separately. But a lot of it is the same. And then once it's consolidated, you're back on the normal track. So definitely a good thing in my opinion.
Talking of consolidation, David, I was slightly wary of consolidation. I think it's one of those very tricky issues in arbitration you don't really want to have to be dealing with. But and I think ultimately the difficulty is this privity point, where you've got different parties. And the LCIA have obviously made a very good fist of trying to encourage this trend, I think, that exists in trying to get more consolidation. Do you think these provisions are going to be easy to implement, and are we going to see lots of jurisdictional issues arise?
Well, look, first of all, I would say this, that I think this is a useful tweak, actually, 22.7. I think actually, if it was thought I was saying that the other tweak in relation to early determination was not also a useful tweak, that's not what I was saying. I'm not sure how often it will become the critical feature of the LCIA rules, early determination, but consolidation under 22.7 might become quite an important feature, actually, of these rules. You mentioned privity and jurisdiction, having been sort of stung in the Astro case, of course, in Singapore on privity. I'm very, very sensitive on this subject. I think the LCIA rules have always been one step ahead of other international rules in this regard. And I think that this tweak under Article 22.7 is a further addition to that. Could I just explain this, though? 22.7.1, which is the first power where all the parties agree, that was always there. Okay, that was in the old rules. under 21, I think, Roman numeral 9. So what has changed? So let's just think for 2 seconds what has changed. And it is the 22.72 that Jamie was alluding to. And that's why I was interested to hear his statistics. He said that there have been 15 applications, of which 8, if I've understood his sort of breakdown, 8 were under this new provision. So I think this is going to be quite important and quite popular. And what it is allowing is for the idea that you can have consolidation of one arbitration with another one, all being subject to the LCIA rules and commence under the same arbitration agreement, and then these added words, or any compatible arbitration agreement or agreements. Okay, so that's it allows you to have a situation consolidation where you're not all under the same agreement, but you've got a compatible agreement, an LCIA agreement, governed by these same rules, and so you can find consent in that family of arbitration agreements. So you've either got the parties all agreeing, irrespective of whether they've got some kind of arbitration agreement or whatever, under the LCIA rules. And so the first method of doing this, you don't have to have LCIA rules arbitration. You can just have the parties agreeing that that's what we're going to do. And the other way you do it is you can have several LCIA arbitration agreements and then the qualifying rules, and either between the same disputing parties or arising out of the same transaction or series of related transactions. And all of that seems to me extremely, extremely sensible to me. So your question is, well, is that going to give rise to jurisdictional disputes? It shouldn't do, because the parties, through this mechanism, have either expressly given ad hoc consent, or they have given consent in advance by signing an arbitration agreement under the LCIA rules, which of course was the mechanism used under the joined-up procedure, which is to allow one or more third persons to be joined in the arbitration as a party, provided that any such third person, the applicant, have consented. And so the question is how do you find consent to that process? I think that we're seeing that imported into Article 22.7 as well. So I think it's useful.
Sherina, the other tool that's available to the tribunal, at least, is the power to order arbitrations to be conducted concurrently. And I would say that people tend to reach for consolidation first, rather than come to this particular power. I mean, in your experience, is this used very much, or do you think we'll see more of it?
So it's funny, actually, even before this rule came out, I mean, it's been there, right? So in an arbitration where I was counsel, we were pushing for consolidation, and actually the tribunal wasn't convinced, and the other side was pushing for all the arbitrations. It was under 14 related contracts to be actually all be separate arbitrations. And so we were thinking, time costs. In fact, I still remember the procedural hearing because my client was the only one in the room who was actually paying the bills of all of this. And, you know, we ultimately came to the compromise of concurrency. What the other party did was they kept doing everything separate, but because the tribunal had ordered that it could be run concurrently, we knew that ultimately there was, you know, if there was a challenge, we'd done everything absolutely correct. So we were being time and cost efficient by trying to, you know, have the same tribunal, same bundles, all of that. So try and cut down quite a lot, and it worked really well. You know, it worked actually brilliantly. So when I saw this change in the rules, I said, well, wow. I mean, now the LCI has actually given us the power to do this, rather than leaving it as an ad hoc power for, you know, for the tribunal. And I think, I mean, it's not, you know, it's not one shot, you know, it's not as if it would fit all disputes, but you would, I think, be seeing this probably in construction disputes, oil and gas disputes, you know, disputes between different lenders, probably. So I think you'll be seeing it in different, you know, types of disputes, but not across the board. And that's what I thought it was a brilliant change.
construction, it would make a lot of sense.
Yeah.
I think in the interest of time, we will move on to topic 3. So Jamie, you have to hold your fire until you can tell your final remarks on that one. Topic 3 is really 2 related topics. Firstly, we've got quite a few new provisions on tribunal secretaries. And then I think probably it's fair to say not huge amendments to do with the emergency arbitrator. But Jamie, I will come to you on this first again to just sort of introduce these 2 related topics.
Yes, indeed. We have brought into the main body of the rules what was guidance sitting alongside the 2014 rules in relation to tribunal secretaries. You can now find that in Article 14A, which really gives you very clear guidance as to the circumstances in which tribunal secretaries can and should be used. So I think there is a general acceptance, certainly on our part, that tribunal secretaries are a very widespread, very accepted part of the arbitration process now. And to be honest, we rarely see complaints about their appointment or their role. Where we do see complaints, I think, are where tribunal secretaries stray from being used for administrative tasks, for arranging documents, for proofreading and that sort of thing, and stray into matters of greater intellectual input, so sort of summarising submissions, reviewing authorities, and even on occasion drafting procedural orders. So the structure of Article 14A essentially, as ever with the LCIA rules, doesn't really prescribe what a tribunal secretary may do, but simply sets up a triple lock on their use. The parties must agree on the use of a tribunal secretary, on the tasks that he or she can perform, and on the fee that he or she is paid. And after that, it's up to the parties and the tribunal to move along. As Rob mentioned, there haven't been huge changes to Article 9. We maintain a very light touch in relation to emergency procedures, the emergency formation of the tribunal and interim measures. It is something that is used relatively rarely. I'm just going to try and give you some data, but I can't find that page. Yes, here we are. So in the year to date, we received 8 applications for the appointment of an emergency arbitrator and 12 for expedited appointment to the tribunal. Of the 8 applications for an emergency arbitrator, 5 were rejected and 3 were granted. And of the 12 for expedited formation of the tribunal, 9 were rejected and 3 were granted. So it isn't used terribly frequently and not especially successfully, I think is the answer. Rob, I'll leave it to you and we can perhaps explore things in questions.
Thanks, Jamie. So let's go back to the tribunal secretaries, and this one's for you, Philip. I guess it is a topic of some controversy. Whenever you hear the word tribunal or the phrase tribunal secretary, you tend to think of the UCOS case. There have been a few cases in the English courts. And I think the controversial bit, I suppose, is, should a tribunal secretary be writing parts of the award where the tribunal is setting out its reasoning, and where is the line? And perhaps an interesting thought is, I always get the impression with judges' judicial assistants that they, do write a lot of stuff that ends up in judgments. David's no, shaking his head.
Absolutely not.
Absolutely not.
Absolutely not. They write sorry to interrupt it. They will write the uncontroversial, bit. The part is the application is this and that, but not the reasoning.
They don't touch the reasoning at all.
No.
So, Philip, is that should we be very much taking the lead from the position in the courts? And is that just the right? Is that even more important in arbitration given the personal mandate of the arbitrator?
So, I mean, of course, you're talking about the English courts. I think, different countries' systems play a...
The US Supreme Court is completely the opposite. They write the whole thing.
Yes. So I mean, I think it's always important to keep that in mind. I know we've focused on the English courts, but the arbitration, international arbitration, needs to think about much more global situations and different attitudes in different courts and different environments. I mean, my sense is that I'm slightly out on a limb on tribunal secretaries compared to a lot of the arbitrators I've talked to about it. So, it's my sense, and it's something that's an evolving situation. But I'm a bit on a limb, I think, because I have concerns about the use of tribunal secretaries. And I think the statistics, as with so many of the statistics that James has mentioned, are obviously useful to know. But it's, the sayings about statistics, and part of the problem with them, of course, is tactical applications in some situations. In relation to tribunal secretaries, of course, the problem is that people don't know what's going on, so you can't complain about it if you don't know. I think my concern about tribunal secretaries is partly that so many senior arbitrators see no problem with them at all. At the same time, there's a lot of senior arbitrators now who basically have their full-time assistants, nearly all of whom are qualified lawyers wanting to be arbitration practitioners, or are, in some sense, practitioners, and so are much more likely to want to get involved in it more than the secretarial function. But I can also see how they can be very useful and efficient and help a lot of people do a good job. So, I'm not saying that I'm anti-secretaries as such, but I do think it's important to be careful what their role is. And I do think that this new provision is a good one, in the sense that it allows the parties complete choice over what the secretaries can do, to the extent that they're willing to stand up to the arbitrators who want to use them, that is. So I like this provision, and I don't see a problem with the tribunal secretary acting as a sort of secretary in the sense of point of liaison with the parties, keeping a record of the procedural steps as they go along. I mean, that takes ages if drafting awards. If you don't do that as you're going along, it's a right pain. So I think that's a good thing. But as Article 14A says, what's very important is that there's no delegation of the decision-making or a function to the secretary. And I guess the question is, what is the decision-making function? What does that really mean? It's very clear from the P versus Q case. Popplewell said that arbitrators must use their own personal independent judgment, which must be right. I mean, the problem is, a lot of people will say, well, as long as they do that after receiving input from somebody, it kind of wipes the slate clean. So, have the input from the secretary, but then as long as you put your own judgment there, it's fine. Well, I'm not comfortable with that. I don't think that that there should be any substantive input from a tribunal secretary. I don't think that the secretary should be using any of their substantive legal training at all. I think that should be, I can see why they're there, but I don't think that's what they should be using as part of their role. I wouldn't want the secretary to be involved in any part of drafting the award beyond maybe providing the format with the case headings and a separate document with the procedural history in it. I think other than that, they should be kept separate from that. I don't think they should be, that of course was the problem in the UCOS case, that they were involved in drafting sections of the award. I don't think that they should participate in the deliberations either, other than as an observer. I can see, the incentive for people often is being part of that process, very interesting, useful stuff for their careers. So I wouldn't say they shouldn't be there observing, but I don't think they should be giving their view on the merits. I know judges, could be comfortable with putting that to one side and reaching their own view, but I just think that in a situation where the parties don't know what's being said and don't have an opportunity to comment on it, that just shouldn't happen. And in fact, Popplewell did say in P versus Q that secretaries shouldn't express views on the substance of the case, which seems to be slightly contrary to some of the other comments about how it's okay as long as independent judgment is exercised. But I just think that it's a bad idea generally. I don't think secretaries should be doing the research on the points of law. I think it would be okay if you gave the secretary a specific task and asked for extracts of books on something, but I don't think they should be asked to research a particular topic and come up with ideas, that kind of thing. Because I think these are all matters that are way too close to the edge and putting far too much emphasis on the arbitrators putting it out of their mind, which some English judges are no doubt very good at, but I just don't trust everybody to be so good. So really what I'm saying, I suppose, is that I think tribunal secretaries should be secretaries in the sense that we're used to secretaries in major law firms. I mean, I say that because I appreciate that secretaries in some firms do a lot more of the legal work than in others. But I think the sort of, the actual administrative role of a secretary is what they should be doing. And that it's fine to have junior arbitration lawyers as the secretaries to get experience, but they should be doing that by observing, not as being apprentices. So, and I think the LCIA rules achieve all of this by putting it all back to the parties, and the parties can say what they're comfortable with or not.
Sherina, do you think there are competing approaches to that in other legal traditions? Or I think Philip and David are coming down very strongly, I think rightly, that arbitrators ought to be, the writing is part of the reasoning. But are there competing approaches to that?
I think ultimately, it's the lack of visibility that is the problem. And the Queen Mary survey actually rightly identified it's not just the parties' lack of visibility, the worry from the parties. Sometimes many a times it's the co-arbitrators as well, worrying about what the president of the tribunal, in the directions they're giving to the parties, to the tribunal secretary. But I do think sometimes, and if it's very clearly defined, it actually does lead to cost and time efficiencies if the secretary is doing quite a bit of the job that Philip just said, that he would trust a secretary to be doing. That does lead to time and cost efficiency. So I think ultimately, if you have trust, and that's a difficult thing for lawyers to do, but if you have the trust and it's really clearly laid out about what is the role of the secretary, I think it's actually quite a useful thing. Not that I've ever actually had a secretary as a tribunal member, but I think it would be quite nice.
I certainly agree that lawyers are notoriously bad delegators. Shall we let's discuss the sort of emergency arbitrator?
Before you get, I just wanted to I might sort of throw a question out to the audience at some stage, because what about the recording of the argument of the parties? I mean, I have drafted more awards than I care to think of, and it is, I've never had a tribunal secretary. It is the most boring thing known to mankind of summarizing, hundreds and hundreds of pages, sometimes on dozens and dozens of claims and subclaims. And then the claimant said this, and at that point you just want to scream, don't you? So I don't know what people feel about that. Is that delegation of the decision making? I don't think so, but I don't know what people think.
I would offer the tentative.
You don't agree with it?
No, I agree with you.
Yeah.
I think one just has to be very careful that they really have so ultimately, nevertheless, go through it anyway.
Yeah.
Nothing is forgotten.
Yeah. No, I mean, I have to say, there's a part of me which agrees with you. I can think of one case in particular where actually the real nub of what was being said by one party was in the further and better particulars of the further and better particulars. It was like some volume, I don't even know what are the pleadings. I mean, you had mind-numbingly dull, but you had to do it.
That's what.
So I think both conditions actually suggests that in any way like you, I remember Paul very argument. She called it very nice, but I don't understand what. I have seen from secretary procedural.
Let us come to the emergency arbitrator, and then we will go to questions. And unfortunately, people will have to come up to the microphones for the benefit of our online audience as well. So I think it's fair to say on the emergency arbitrator provisions that there haven't been many changes, but people still have in mind this decision in 2017 in Gerald Metals and Timmis, this sort of concern perhaps that if the emergency arbitrator is available, then you can't go to the court for interim relief. And, you know, David, do you think this is a problem that if it indeed it is a problem, that the LCIA can solve itself, or ultimately are we in the hands of the court here as to what the appropriate approach is? And we have to look back at the Arbitration Act.
So, I mean, two very short answers there. The first is this. I think it is quite important to say this at the start, which is one of the most common forms of, if you like, emergency or urgent interim relief, which is sought in the courts in the arbitration context, will be an anti-suit injunction. Someone is breaking their contract to go to arbitration, and then they have to be restrained, or you're seeking them to be restrained. And that, I'm not saying that is 90%, but it is one of the most common forms of interim relief, which is sought on an urgent basis. That is relief which is sought under Section 37 of the Senior Courts Act, and it's out with the restraint of Section 44 of the Arbitration Act, and that was determined by the Supreme Court in AES. So yes, Gerald Metals is a problem, but at least one bucket of, perhaps the most common bucket of application, is out with the Gerald Metals problem. So second point, Gerald Metals. It is a problem, and it is a problem which even the LCIA is not powerful enough to solve, because it's a problem from the statute. And the jurisdiction of the court under Section 43 and Section 44.3 and 44.5 is circumscribed. It's nothing it's not as though the court could say, in appropriate circumstances we can act in this way or whatever. It says shall only act when. And so the answer that in the Gerald Metals type case, which was an unsuccessful freezing order type of application, the existence of the emergency measures or emergency procedure in the LCI scuppered as a secondary form of reasoning. Actually, in fact, it turned out they didn't have a very good case for a freezing order anyway, but leave that to one side. So yes, Gerald Metals is a problem. And I'm just going to, one final commentary on that. My experience in relation to emergency relief and expedited formation of tribunals has been very, very mixed, not just with the LCIA, but all manner, SIC and Kuala Lumpur, you name it. It's been very, very, very mixed. And funnily enough, this brings us right back to the beginning of early determination. I think that there is a common theme here, which is that either tribunals or emergency arbitrators are a bit reluctant to sort of alter the landscape too much until they know a bit more about the case, whereas judges have no fear at all. And they just get straight in there with their big size 12 boots and kick the parties around a bit until they're happy with what's going on. So I think there actually really is a difference between arbitration and court in that respect.
Philip, any final thoughts on Gerald Metals? I seem to recall from your book, you said it was a decision very much on its facts. Do you think it's a problem that sort of applies more widely, or is that something that we can just be constrained in its own little?
So I'm not sure. I mean, I did talk about it in the book, but I'm not sure what that reference was. I mean, basically, I think Gerald Metals was the funny thing about that was that everybody seemed to think that there was a problem with it as a decision, and I thought it was right what it said. So I didn't, to me, it's right, and I think it's quite interesting how. We're desperate to keep the courts out of arbitration, and everyone emphasises that on the one hand, and then when it comes to the interim relief, everyone thinks we should be able to go to court. That's slightly strange. But I mean, I think the main thing for me is that in practice, when you really need to go to court, you absolutely can, because one of the obvious reasons is when you have to bind third parties. So there are situations, the main situations where you need to go to court. I think you still can, and the others where you could just as easily go to the arbitrators. Well, having chosen arbitration, I find it difficult to see why that shouldn't be where you should have to go. So I don't really have too much of a problem with it in practice.
Sherina, you're equally happy with the decision?
Yeah, no, I mean, I agree with Philip, but what I do is, when we are approached by the project finance team at 5 p.m. on a Friday to look at the clauses, we do try and build in language on interim relief from the court, if that's ultimately what they want to do, because you just don't want that anguish. Yeah. So we build it into the clause, and then it's there.
I seem to remember that's one of the first seminars by the Chartered Institute I came to. I remember there was a great debate about whether you should be disapplying the emergency arbitrator provisions. So clearly something that remains live. I think probably it's time for questions. So let's start with the audience here. I think there were some questions from that part of the room, but if anyone has a question, now is your opportunity. But could I emphasize, please, could you head towards one of the microphones if you would be so bold?
I had a question.
If you wouldn't mind. No, the one to your right.
Not really a question. Not really a. Hi, Daniel Janoglia, committee member. Not really a question, just a point, but possibly a question about hedging my position. The use of delegating the writing of the parties' submissions may come with the risk of it being misstated, and the need and the concern about that leading to the arbitrator spending perhaps more time checking that it's been properly stated back to the original documents, and so it's not a straightforward one. Yes, I can see, and I think the point was made by the person over there, that there may be ways of controlling the process. But I just wondered whether, in fact, this is a workshop point when we next do a workshop or a future workshop, as to how best to sort of bring together the resource of a tribunal secretary in a way which is safeguarded, so to speak, that you don't end up with a duplication of work and the wrong understanding of the case coming through.
Any thoughts from our panel?
Just very quick, the more I think about this, I tend to agree with Daniel's point, and actually my slight concern is when you summarize and frame the argument, very often it's framed in a way where it only results in one answer. And so maybe that's your job. You just have to, however dull you think it is, maybe that's the job. You just have to spend the time with the submissions and understand them in a way where you think you're actually summarizing them yourselves accurately. And then that might help lead you correctly to the answer.
I mean, I think if it's a purely factual matter, like the procedural history, or if you could characterize the collection of the arguments in a purely factual matter, then that would be okay. But the moment you have to select, I think that starts getting quite dangerous.
Thank you very much.
It's got a long walk, isn't it?
Actually, I should say you can go up to the podium as well. But I was very much told that people just would not want to do so. But you're very welcome to do that too.
All right. Well, since I'm here, thank you. I really enjoyed the discussion so far. This is a throwback to the first point where we discussed, or rather you discussed, the use of virtual hearings in the rules. And I have a question on procedural fairness. And where the parties don't agree, often there's no agreement, and perhaps one party vociferously says that relying on a virtual hearing would somehow negatively sort of impact their right to be heard or present their case. How would the rules deal with that, or how should arbitrators address the issue of procedural fairness where the parties don't agree?
Shall I start? Well, I don't think there's ever been a problem with the LCIA rules in relation to virtual hearings. The ICC had a problem because of the reference in the rules to in person, which they decided didn't actually mean in person. So to get around it, but then everyone's promptly changed their rules to say that it's all fine now. And so I don't think that parties really have got much of a leg to stand on complaining about virtual hearings, would be my view. I think it would be very hard to run. I mean, certainly in the situation that we've had up until now, where there's been little choice, it would be almost impossible, I think. I have to say that I think that the virtual hearing can work very well. I mean, from an arbitrator perspective, I actually like the virtual hearing situation. You know, it gives you lots of advantages, and I quite like the camera straight on the face of the witnesses and the counsel and all the rest of it. And I find it quite good. I mean, I think the downside is from the other side. It's when in the counsel team, cooperating with your team is more difficult, or has been more difficult in the scenario of COVID, where you haven't been able to all be together. I think if you're actually if it's a virtual hearing and you're getting together in the office, which is what presumably would happen now, I think that's better as well. So I don't really have a problem with virtual hearings. I'm not saying that I would always want a virtual hearing, and some situations clearly better to be in person. So I hope that in the future we get a mixture of the two, but I don't think that they've been such a bad thing.
Can I just throw this up to Jamie? I mean, from the LCIA's perspective, how do you feel virtual hearings have gone in COVID? I mean, it seems very much business as usual to some extent. People have adapted quite well. Is that your view?
Yeah, I think if anything, we saw some applications to postpone hearings at the start while people took stock of what that actually meant. I think we were very conscious too that while the courts were working remotely, it would be very hard to argue in the context of a challenge to an arbitration award that it was somehow unfair. If that was just the reality that everybody was dealing with, and you either got on with it and you had a virtual hearing or you didn't, and that you probably get very little sympathy from the court. I think it is something that we're going to have to live with, and the rules facilitate it. We don't mandate it. It is something for the parties to resolve with the tribunal. We're often asked, I think, whether you are compelled to have a virtual hearing, whether you want it or not, and the answer is, of course not. But it is something that you're going to have to resolve between the parties and the tribunal. And we simply say that is a possible means of doing it.
That's a really interesting question. As counsel, I can just tell you, practically speaking, the amount of clients who have asked if we could use the fact that we don't want a virtual hearing as a tactic to delay the arbitration. It practically pretty much, I mean, and I deal a lot with the Indian subcontinent, where they believe that adjournment is their birthright. And nearly every client has asked the same question. And we have said, no, you're going to make a fool of yourself. It's going to be shot down. We will not make such a submission to the tribunal. But it's a very live question and a very practical one, because we face it all the time. And I think now that we're coming out of the COVID world, we'll face it even more.
There's a question from our online audience, I think prompted, Sherina, by your reference to summary judgment. And the question is, do you think there will be a higher bar for an early determination as compared with the summary judgment under the CPR? Discuss.
David, what do you think?
I go back to what Philip said in his comments. An early determination is properly to be seen as taking one issue or maybe series of issues and having those issues argued out, possibly separately, as a separate stream from the main merits. And so I don't think it should be confused with summary judgment, is the honest truth, because actually, for example, one of the questions could be, do we have jurisdiction? It's nothing really to do with summary judgment. You just have to determine that issue. Likewise, it could be, at the other end of the extreme, it could be more akin to summary judgment. For argument's sake, let's say there's a claim in conspiracy or whatever, but one of the elements of conspiracy is just not present. And so you're analyzing the pleading and the response and saying, well, that isn't really properly arguable. It's manifestly unsustainable or something like that. So I don't think it's going to be the same as summary judgment. I think it can be used quite flexibly depending upon which of the three elements of early determination you're proceeding.
Are there any other questions from our audience? Yeah.
Hi, good evening. Thank you very much. Karen Wong from Zhongwen Law Firm London office. So I think my question actually dovetail really well with early determination. I'm particularly interested in this specific topic because I believe my firm actually contributed to one of the 6 undecided cases out of the 10 applications. So, so I think I could perhaps like add another layer of the discussion to try to share a little bit of my experience in actually using this new provision. So what we experienced in this dispute is quite complicated, and actually, I understand what Jamie had initially suggested, that when LCIA drafted or borrowed this from CIAC to begin with, is to try to have a more efficient or a more streamlined conduct of the hearing. But what we have experienced is that it actually delay the process even more, because because this case is actually not that straightforward, and it coupled with the arguments such as res judicata were mentioned, and there's also anti-suit injunction was in play. So you can see parties are trying to use this new provision as a litigation strategy to further delay the proceedings, because there are parallel proceedings running in Africa. And that's why a lot of parties are trying to exploit this provision as litigation strategy. So I'm just wondering from the panelist perspective, do you think this is a serious concern going forward? Thank you.
I just wanted to say very quickly that I think that's an extremely valuable contribution. And my experience, both as counsel and as arbitrator, is that, in fact, the LCIA is one of the most streamlined set of rules. I was very interested to hear that statistic about, 11 to 12 months being the average time for resolution. Parties are nearly always better off backing that horse, the 11 to 12 months, with a, sort of a reasonably straightforward timetable, rather than the interesting diversions of, should we try for this, should we try for that? It is almost certainly going to end up with a process which is longer than 11 to 12 months.
I mean, it's such a difficult threshold for the early determination that I think that what should happen is that a party trying to use it tactically should raise it. The other side should say, you've got to be joking, and the tribunal should say, yes, go away, and then it should all just move on. That's what should happen. I mean, I think it's the same with preliminary issues. It's the same point as I made earlier, that you've got to be very careful that you don't end up causing yourself more of a problem by supposedly trying to make things more efficient. And I think, the LCIA can provide a very in relative terms, quick process and lean process. But also, I think that we need to think about horses for courses the whole time. I mean, yes, 11 months or shorter is very impressive for a full-blown arbitration, but we might all have different ideas about what a full-blown arbitration is. And a relatively straightforward dispute before a contractual interpretation point before a sole arbitrator is not the same as some, multi-party, 3-member tribunal construction project nightmare. And nobody should be trying to resolve that in 11 months if it's not appropriate. So horses for courses always. And I think that the important thing is the arbitrators have the tools at their disposal to deal with things efficiently. And if early determination is appropriate and the party is arguing for it, then yes, use it. But it shouldn't be allowed to be used as a tactical weapon in situations where it's clearly not going to be straightforward.
Sherina, any final thoughts before we let Jamie have rightly, I think, the last
Nothing
word?
for me. Nothing more to add. Completely agree.
Jamie, I think it's over to you to bring things to a conclusion. And I think you're on mute. That's
It was going to happen, wasn't it? I only came off mute because I sneezed. I began the evening by pointing out that arbitral institutions are traditionally pretty resistant to changes in their rules, preferring to maintain the status quo, which generally is appreciated by users and arbitrators. But it is important for arbitral institutions also to keep pace with changes. Changes to the practice of arbitration and to evolve. Updating the rules has afforded the LCIA the opportunity to reflect reality and to codify changes in the way that we and other institutions connect with our users and administer their cases, and changes in the approach taken by arbitrators to particular issues that they've developed over time. So we hope, obviously, that this evening has given everyone an opportunity to reflect on some of the important changes that the LCIA saw as important in its most recent update, and has given a little glimpse on how those changes are being used in practice. And your contributions have been very welcome and very well received. I would like to thank the panellists for giving up their time this evening and for offering such insights on the rules and the practice of arbitration generally, particularly with their own wealth of enthusiasm and experience. Thanks in particular, as I said, to Latham and Watkins, and especially to Rob, who's done a terrific job, not only driving the event this evening, but also behind the scenes, getting us all in order and setting all of this up. I should also mention the much maligned events team of the LCA, Kelly and Nadine. And for those of you in the room, I suspect that Ben is about to tell you what happens next. So I won't steal his thunder, but I just wish you a very good evening, and hope that you keep safe and well, and that perhaps that we'll all be together in one room for the 18th annual event in 2022. Thank you.